Tom Spiggle with the Spiggle Law Firm, where we represent people who've been fired or afraid that they might be. Today, I want to talk to you about teacher rights in the workplace, particularly as they apply to this, this post-COVID era. Now we're coming back out. Schools are obviously opening back up, and teachers are coming back, in many instances, into the classroom. What are teacher rights in relation to returning? Let's say you have a health condition and you don't want to return. You're worried about returning, or you don't think the school building is safe. What is your legal recourse? Are you subject to getting fired? Now, let me say this all varies at some level state by state. State laws are a bit different, particularly on whistleblower issues, but there are some overarching principles that apply, and that is, coverage under the Americans with Disabilities Act, coverage under the Family Medical Leave Act, and whistleblower or occupational safe and health regulations and whistleblower actions relating to those. So let's start with the first one, the Americans with Disabilities Act. If you have a disability, and the ADA is very broad in what it calls a disability. It could be mental, it could be physical. It's basically anything that interferes with a major function of the body. And if you go to the EEOC's website at eeoc.gov, and on our website you can find some more information about what disabilities are uncovered. But it's a very broad definition. But if you have a disability, let's say you have diabetes, you have MS, you've got PTSD, all these things could be covered under the Americans with Disabilities Act, then your employer, your school board, your school system has an obligation that if you were claiming rights under the ADA, saying I need an accommodation, which may be, like I don't want to return to the classroom until everybody's vaccinated. That's just one example. Then the employer has to engage in what's called an interactive process with you. They have to sit down with you and say, okay, what accommodation do you need to make this work? And let's say it's I want to stay home and continue to teach, virtually for however long. Let's say this next quarter. Then the school system needs to decide if that is a reasonable accommodation that they're going to grant. And they can say no, or they can offer an alternative one. They can't just refuse to engage in the dialogue. That would be a violation of the ADA. And if they are not engaging in it in good faith, basically they're just sitting there at the table and letting you talk, that also can be a violation. And just the fact that they say no to your accommodation doesn't mean that your accommodation request wasn't reasonable, that you couldn't prevail in an action under the ADA. So you can learn more about the ADA at those websites. If you did need to pursue something, which you can do while still employed, is you can file what's called a charge with the EEOC or with a local agency. For instance, the Arlington County Office of Human Rights. If you're in DC, the DC Office of Human Rights, they also will take those claims and do what's called cross-file with the EEOC, and they will investigate. Sometimes the investigations aren't that great, but they will investigate whether or not this claim is going to move forward, and there can be opportunities to mediate. It further provides you protection because if you file one of these claims and then there's action taken against you, you have a retaliation claim on top of the ADA claim. So you could lose that ADA claim and still win the retaliation claim. For instance, you tell the school system that you have a covered disability, you ask for an accommodation, they go through the interactive process, they're not willing to grant you the accommodation that you want, and you file a charge, and then they bring some action against you. They demote you, they fire you. A court or jury could look at that and say, well, the initial accommodation that the school system declined, that was not inappropriate, that was not illegal. But then retaliating against you for the very fact that you participate in the process is another violation and is illegal. So just be aware of that. Another related law is the Family Medical Leave Act, which is the only law that allows for some leave, right? The ADA leave can be an accommodation, but it's not required, right? Giving you leave is not required. And let me say also as to the ADA, now with teleworking and teaching remotely and teaching virtually, now that it's become much more widespread, it is more difficult for an employer to say, well, this just won't work for us, because we all know that it can to a certain degree. So that's something that's in your favor. Under the FMLA, you are entitled to, depending on, some states are different, but under the federal law, up to 12 weeks of unpaid leave. It can be in a block or can be intermittent. Now, the standards are different. It's not a matter of disability. You have to have what's called a serious medical condition, which has to be somewhat serious. You have to be under continuous care of a doctor. You have to be hospitalized. And continuous care of a doctor is pretty broad. So if you're seeing somebody regularly for, let's say, PTSD, if you're seeing somebody regularly for your MS, let's say, then you could be entitled to protection under the Family Medical Leave Act. Again, up to 12 weeks of leave. It's not required to be paid, at least under federal law. So that's a negative. Sometimes school systems will continue to pay during that period, but they're not required to, at least not by federal law. And again, there are penalties for a school system, interfering with your leave. So either, not allowing you leave when you are supposed to, when you're entitled to get it, or when you get it, interfering with it. So they're reaching back out to you. They're asking you to do things. That's called FMLA interference, all protected under federal law. For these violations, you would not file with the EEOC. You can file them with the Department of Labor. I have not found that to be very fruitful. I think your better course of action is either proceed on your own or hire an attorney, but do know that it is an option to file with the Department of Labor. They're very slow. I wouldn't expect that you're going to get a result, but it's better than doing nothing. And as with protections in the ADA, you have retaliation protection. So, let's say that you are in fact not entitled to FMLA leave, but the school system takes action just because you filed it. There can be some, that's a law violation that you can pursue as well. So ADA, FMLA, and then we've got whistleblower protections, which are really a matter of state law. But then as a matter of federal law, you have the Occupational Safety and Health Administration, which has its own guidelines for worker safety, and they've been very active in the COVID space in setting forth, what kind of protections apply. Virginia, there's a very robust state law that was passed earlier this year. It may sunset, but it did provide a number of whistleblower protections. It required employers, based on their size and their risk category, to take certain steps to protect their workers. And if they didn't, it could be a violation. And if an employee was retaliated against for, again, filing a claim or raising these issues, then that's a whole separate, that's another legal violation that you could pursue in court, and you can get attorney's fees and all that. So those are the three big ones. You got your ADA, you got your FMLA, you've got whistleblower, either state level or Occupational Safety and Health Administration regulations. You can, of course, do this on your own. You don't need an attorney. You can write a letter to your school board, or to your principal and engage with them on that level. That may get you the relief that you want. But as you get further into it, or if the school system is not providing you the relief that you want, it may be worth hiring an attorney to help you proceed, but really proceed with some what can be complicated and interrelated laws. So, but just know that there are some protections available to you. There's also the grievance process that differs by school system. Sometimes these are things you can grieve, sometimes they're not. Sometimes grievance processes are helpful, sometimes they're not, and you could do them concurrently. You could do the grievance process and still pursue one of these other claims, but it's important that you know your rights and that you know that there are some protections available. I wish you the best of luck in your teaching career.